When conducting a major M&A transaction in Vietnam, it is not just about negotiating terms and closing the deal. If your transaction meets certain thresholds, you may be legally required to notify the Vietnamese Competition Authority before closing. This process is known as merger filing, and failure to comply can lead to fines, delays, or even the nullification of your transaction. In this video, we explain when a merger filing is required in Vietnam, what the process looks like, and how to avoid regulatory risks that could jeopardize your deal. Vietnam's law on competition regulates economic concentrations, including mergers, acquisitions, consolidations, and joint ventures. Under this law, any transaction that qualifies as an economic concentration and exceeds specified thresholds must be filed with the National Competition Commission for appraisal. The merger filing requirement is mandatory and must be completed before the transaction is finalized. If your deal closes without prior approval, it may be deemed illegal under Vietnamese law. Economic concentration in Vietnam includes 4 primary forms: the merger of 2 or more enterprises, the acquisition of all or part of another enterprise sufficient to control or influence that enterprise, and the creation of a joint venture between independent enterprises. These definitions apply regardless of the nationality of the parties, meaning that foreign-to-foreign transactions may still trigger Vietnamese merger control if the target has a substantial business presence in Vietnam. A transaction must be filed if it meets or exceeds one or more of the following thresholds as defined by the law and subsequent guidelines. First, the combined total assets of the parties in Vietnam exceed 3,000 billion Vietnamese dong. Second, the combined total revenue in Vietnam exceeds 3,000 billion Vietnamese dong. Third, the value of the transaction exceeds 1,000 billion Vietnamese dong. Fourth, the parties together hold a combined market share of 20% or more in the relevant market. If your deal meets any of these conditions, a merger filing is required prior to closing. The merger filing process includes 2 phases: a preliminary review and, if needed, a full competitive impact assessment. The preliminary review lasts up to 30 days after a complete dossier is accepted. If no significant concerns are identified, the competition authority may clear the transaction at this stage. However, if the transaction may restrict competition in Vietnam, the case will proceed to a full assessment phase, which can take up to 90 additional days, extendable in complex cases. Timing must be factored into the transaction schedule to avoid delay penalties. To submit a merger filing, the parties must prepare a comprehensive dossier that includes corporate information, transaction structure, market share data, financial statements, business licenses, and economic rationale. The dossier must also include an analysis of the relevant product and geographic market, competitors, and potential anti-competitive effects. All documents must be submitted in Vietnamese or with certified translations. The preparation of the filing is technical and requires careful attention to regulatory expectations. The National Competition Commission assesses whether the transaction causes or may cause significant restrictions on competition in the Vietnamese market. Factors include market concentration, market entry barriers, buyer and seller power, and effects on consumers. If the deal is found to reduce competition substantially, it may be prohibited or subject to conditional approval. Penalties for failure to notify include administrative fines and potential invalidation of the transaction. Therefore, early legal assessment is vital. Certain transactions may be exempted from merger filing if they fall under specific categories, such as transactions between affiliated companies, temporary acquisitions for resale purposes, or transactions cleared by foreign competition authorities that meet mutual recognition standards. However, these exemptions are narrowly interpreted, and companies should not assume the deal qualifies without legal confirmation. Foreign investors are advised to consult Vietnamese legal counsel before relying on any exemption. Merger filing can impact the timeline of your transaction. It must be completed and approved before closing, which may delay the signing or execution of the final transaction documents. Investors should factor in at least 1 to 3 months for the competition authority to process the filing, depending on whether a full assessment is required. In Vietnam, merger filing is separate from other regulatory procedures such as investment registration certificates, IRC, enterprise registration certificates, ERC, or sector-specific licenses. This means that even if your deal is approved by other agencies, it can still be held back by a pending merger filing. It is essential to coordinate merger control compliance with all other legal steps in the M&A process to ensure a seamless closing. Given the complexity of Vietnam's competition laws, legal advisors play a critical role in determining whether a filing is required, preparing the dossier, communicating with regulators, and managing the review process. A local law firm with merger control expertise can help assess thresholds, define the relevant market, prepare economic analysis, and handle interactions with the National Competition Commission. Early legal involvement reduces the risk of incomplete filings or unexpected objections from the authority. At LTS Law, we guide clients through all legal aspects of cross-border M&A in Vietnam, including merger filing obligations. We assess your transaction against legal thresholds, prepare and submit your dossier, represent you in regulatory discussions, and keep your deal on track. Our experience with merger control procedures helps international investors navigate Vietnam's evolving competition framework confidently and efficiently. Planning a major M&A deal in Vietnam. Don't let competition law risks derail your investment. Contact LTS Law or visit lts.com.vn to find out whether your transaction triggers a merger filing and how we can assist with compliance. With the right legal strategy, your deal can proceed smoothly and lawfully. No surprises, no delays, just results.